And now for our guests and esteemed candidates for the Oregon Supreme Court. I'll keep the introductions fairly short because they're going to give opening statements of about 3 minutes going over their biographies. But in alphabetical order, and on your far left, or your far right, my far left, Richard Baldwin is a judge on the Multnomah County Circuit Court. He served as a trial judge for the last 11 years. Prior to that, he was a legal aid lawyer and helped found and was the executive director of the Oregon Law Center, one of our legal aid firms. Earlier in his career, he had a private practice representing employees. He graduated from Northwestern School of Law at Lewis and Clark. Next to him and in the middle is Nina Cook. She's a partner at Sussman Shank. She works in complex business litigation, appellate law, and professional liability and employment defense. She's listed in Best Lawyers and Super Lawyers. She has also served as a pro tem Multnomah County Circuit Court judge since 2007, and she's a graduate of Willamette University School of Law. On your left, closest to the moderators, is Timothy Sercom, who's a judge on the Oregon Court of Appeals. He's served on that court since 2007. Prior to being appointed to that court by Governor Kulongoski, I believe, he was in private practice, first at the Harang Long Law Firm and later at Preston Gates. He primarily practiced in government, land use, and appellate law, and he's a graduate of the University of Oregon School of Law. And thank you all for joining us. I'm going to briefly describe the format and then turn this forum over to the candidates. We're going to have opening statements of 3 minutes each. Then we're going to go through rounds of questions where each candidate will get to answer the same question. They'll have up to 2 minutes each to respond. And then we're going to have concluding statements of 3 minutes each at the end. One final caveat that some of you may be familiar with. In drawing up these questions, we kept in mind the Judicial Code of Conduct, and particularly Rule 2-103, that provides a judge or candidate shall not, while a proceeding is pending in any court within the judge's jurisdiction, make any public comment that might reasonably be expected to affect the outcome or impair the fairness of the proceeding. So with that in mind, we tried to have fairly broad legal questions that we think the candidates will be comfortable answering, but of course it's up to them how far they want to go in their answers. So we had a drawing before the forum to determine the order, and Judge Sercom is going to begin the opening statements, then Judge Baldwin, and then Ms. Cook. Judge Sercom.
Thank you, Scott and Megan and Janet and Chuck and to ACS and to the appellate practice section for putting this program together. I think all of you have appeared in oral argument before me, and you know I'm somewhat of an active interrogator in oral arguments, so turnabout is fair play, I think. So the question of the day is this. What kind of person should we have on the Oregon Supreme Court? What are the qualities and characteristics of a judge candidate that would allow you as a voter to confidently predict that the candidate will be an effective and productive justice on the Oregon Supreme Court? And to answer that question, let me state the obvious. The work of the court is analytical. Its primary job is the construction of state statutes and state constitutional provisions. There's very little left in the common law to the imagination of appellate judges. The court does that interpretive work in the context of appeals from both criminal and civil trials, as well as from decisions of administrative agencies and officers. My thesis is that analytical work is most effectively done by a person who is trained in legal analysis, knowledgeable about the subject areas of the court's work, who's a good writer, and able to work in a collaborative manner. And my brief here is very simple, and it is that summary of the qualities of an effective Supreme Court justice describes me. I've had a lifetime of training as a legal analyst and writer. From my work as a Supreme Court clerk, after graduating from the University of Oregon School of Law in 1976, I clerked for Justice K.J. O'Connell and Berkeley Lent, two very dissimilar judges, I must say, in temperament, to my work of 30 years as an appellate practitioner before the Oregon Court of Appeals and the Oregon Supreme Court. I handled over 50 matters before the Oregon Court of Appeals and over 30 matters involving a decision of the Oregon Supreme Court. My training as a legal analyst and writer continued through the publications and the speakings that I've done as a teacher and a writer, and it finally includes my 5 years on the appellate bench with the Oregon Court of Appeals. So I know and understand the areas that and the substance of the laws that are applied by the Supreme Court. I've been a successful collaborator with my colleagues on the Court of Appeals. I have a proven track record as an accomplished jurist who is among the more productive judges on my court. If elected to the Supreme Court, I think there's going to be much for me to learn about being an effective justice on the court. It took me a long time to learn to be an effective and productive member of my court, but the step up from the Court of Appeals will be a short one, and that's why I think I'm ready to serve the people of this state as a justice on the Oregon Supreme Court from day one of my term. Thank you.
Judge Baldwin is next.
Thank you. And good afternoon, everyone. Thanks for being here and showing your interest in a very important institution and an important race. I'm happy to be here this afternoon and appreciate the opportunity to talk with you about my interest in becoming an Associate Justice of the Oregon Supreme Court. All three of us this afternoon will be talking about our experience and background. I would ask that you assess how pertinent our background is from the standpoint of the Supreme Court as a deliberative body. I would ask you to consider which one of us will bring the most to the table to strengthen our distinguished Supreme Court. And I would also ask you to consider what kind of practical experience might be missing from the Supreme Court at this time. It is an important election because the Oregon Supreme Court, the highest court of our state, is a democratic institution charged with securing the rights and liberties of all Oregonians. So let me just give you a brief thumbnail sketch of my background and experience. I grew up in San Jose, California, and graduated with a bachelor's degree in philosophy from San Jose State College in 1970. My wife, Teresa, and I then moved to Oregon, where I attended and graduated from Lewis and Clark Law School. After law school, I served as a law clerk for Judge Robert Foley on the Oregon Court of Appeals. I then went to work for Multnomah County Legal Aid Service, representing low-income clients in eviction cases and in family law matters. After 4 years, I established my own law firm based on referrals from legal aid programs. I represented individuals and families, injury claims and employment claims and family law matters. During 10 years of private practice, I did an extensive amount of trial work. I was a trial lawyer. I then returned to Multnomah County Legal Aid to serve as litigation director. During that period of time, I supervised all the attorneys in the office and I supervised all the major litigation. After 5 years, I became the first director of the Oregon Law Center, a statewide legal services program. And during that period of time, I served on the Oregon State Bar Board of Governors with other lawyers, helping to develop an ethic of access to justice in the bar. On the bench, I've handled hundreds of civil trials and hundreds of criminal trials, major felonies and murder trials. I'm on the panel recently selected to do complex civil litigation as part of a civil litigation court set up by Chief Justice Demunis. I've also worked on treatment courts. Our Supreme Court historically has had trial judges with a lot of experience. Right now, they don't have a sitting justice with that experience. We need a trial judge on the Oregon Supreme Court.
Just a reminder, our microphones are picked up for the video, and because of the loud air conditioning, I'm getting looks that occasionally people from the back can't hear us all. So we'll all do our best to speak up as loud as we can.
Okay, thank you. Thank you all for being here. I hope you can hear me in the back. It's good to see you. Thanks for coming. I'm running for one of the 2 open seats on the Oregon Supreme Court because I think what Oregonians need now on their court is somebody with a diverse background of experience and skills, and that's what I would bring to this position. I've practiced law for 21 years in the civil arena. I've represented plaintiffs, I've represented defendants, I've represented individuals, I've represented businesses. I've represented unions and union members. I've had a broad-based experience in those 21 years. Before I graduated from law school, I am the only one of the three of us who's actually practiced criminal law. I had the honor of prosecuting cases in the Marion County District Attorney's Office while I was still in law school. So I've practiced criminal law, civil law, and since 2007, I've been on the Multnomah County Circuit Court bench as a pro tem judge. Those experiences is what I would bring to the bench, and a different experience that I think my opponents bring, and something that I think we need on the bench now. The other thing that I would bring, and I'd ask you to think about this, is you all have to evaluate not only each of us individually, but as Judge Baldwin said, what is it that would strengthen our court, which right now has fabulous people on it? Who is it that will add something new and different and better to our court? And what I mean by that is the following. Right now, of our 7 justices, we have 3 who are on the court directly from the Court of Appeals. When Judge Dave Brewer joins them in January, he's running unopposed for the other position, there will be 4 justices directly from the Court of Appeals. I think that's fabulous experience. I think we need it. I just don't think we need 5 of 7. When Judge Brewer joins, he also brings with him not only his experience on the Court of Appeals, but his experience as a Lane County Circuit Court judge. So as Judge Baldwin said, we need that perspective of a former trial court judge. That's also what Judge Brewer would bring to the court. So the perspective I would bring is that of someone who's been in private practice for 21 years, representing all kinds of different people, different entities in a variety of areas of law. The third thing that I would bring is my commitment and dedication to access to justice. And through the good work of many of you in this room, when I was president of the bar, we started the first loan repayment assistance program, statewide program for those law students who wanted to go into public interest law and couldn't afford to. They could now do that. We established a leadership college, which it was a commitment to retain and assist and support women and lawyers of color in their professional goals. And one of the things I was most active in is funding for the judiciary and our indigent defense. So what I would bring to this position if I'm successful is my diverse experience, my diverse perspective, and my commitment to access to justice.
Judge Baldwin, and this question applies obviously to the 3 of you, but compared to the other candidates, what aspects of either your personal background or professional background that we might not know about by reading a resume or Googling you, do you believe may make you uniquely qualified to serve as an Oregon Supreme Court judge?
And again, I'm still getting signals, so we're all going to try and keep our voice up as loud as we can. Is it?
I have some ideas. We
we
have
stand?
a couple of seats up front, so if people want to move up front, that would help. And then maybe what we could do is all of us could stand up when we talk so that we're not talking over people's heads.
I think that makes sense.
But do some volunteers want to come up to the front and fill up the seats? Okay. All right.
So why don't you repeat your question?
Okay. All right. To repeat my question, Judge Baldwin, compared with the other candidates, what aspects do you have, either personal or professional, that we don't know about you, that we wouldn't know by Googling you or looking up your resume, that you believe make you uniquely qualified to serve on the Oregon Supreme Court?
And should I stand?
I think
Yeah.
it'd be better for the audience.
Okay, and if the folks in the back can't hear me, raise your hand so that I can speak up a little bit. I fell in love with the legal profession somewhere along the way and found that it's the best profession in the world for somebody who is a lifetime learner. From the time I started practicing law, I focused on how to be an advocate. I learned trial work, and after I got good at that and learned how to persuade in an adversarial process as a trial lawyer, I was able to accept a new set of challenges as a director of litigation and executive director of the Oregon Law Center. I'm a nudger. I nudge other people sometimes, but I also nudge myself, and I've nudged myself into different challenges all the way along the way. When I became a director, I got into mediation and was trained in mediation, and that helped me become an administrator. And I learned how to collaborate and start collaborative projects. When I set up the Oregon Law Center, it was necessary to do that in order for low-income Oregonians to continue to receive a full range of legal services. I worked with every legal aid program in the state, worked with the bar, and in doing so, was able to really get something done that was critically important for low-income Oregonians. So I started learning how to be more collaborative, and when I got on the trial court bench, had to shift gears in terms of the role of a trial judge, learned that different role, but also learned more about innovation from the standpoint of starting a drug treatment court, starting Multnomah County's first mental health court. I'm looking for new challenges, and I'm finding that in doing public service, it's extremely fulfilling and satisfying, and that's why I'm running for the Supreme Court.
Yeah, the same question to Judge Sercom.
You know, as my my resume lays out my career of over 30 years as a private practitioner before I spent the last 5 years on the Court of Appeals. And when I was in practice, 14 years in Eugene and 16 years in Portland, I also, as did Ms. Cook, represented a great variety of people in civil and appellate litigation, in administrative proceedings. What you look at when you see my resume is more representation of governmental entities, of businesses. So I wanted to emphasize just for a moment the work that I've done representing individuals in the legal process. In the beginning of my practice, I practiced with Art Johnson and Les Swanson in Eugene and represented plaintiffs in a number of cases. I represented individuals as well in domestic relations cases, landlord-tenant disputes, and professional disciplinary matters, among many other areas. I've throughout my career, I've represented individuals involved in the land use planning process, both in opposing environmentally destructive development along the McKenzie River, as well as destructive development in wildlife habitat areas on the Oregon coast in the Big Creek development. That particular case involved work on behalf of individuals before the Lane County Board of Commissioners, the Court of Appeals, and the Supreme Court before establishing in the Warren versus Lane County case a key precedent on environmental standing. Finally, I've represented individuals in civil rights and criminal defense, civil liberties issues throughout a good chunk of my career as an ACLU cooperating attorney. The most significant work in that area was perhaps in the mid-1980s through my representation of Earl Henry in the State versus Henry case, a case that ultimately in which the Oregon Supreme Court overturned the obscenity laws of the state in 1987.
If I understand Janet's question correctly, I think where it goes is, who are we as people? My colleagues and opponents are phenomenally well qualified and professional and wonderful jurists. But who are we as people? We've got a head and we've got a heart. And I'll just share with you one story about my heart. I've already mentioned my professional commitment and dedication to access to justice. I didn't connect these dots, though, until just a few years ago to try to figure out what was it about who I am that made me so passionate about the good work that so many Oregonians and Oregon lawyers do in the area of access to justice and helping people who need it. And I've come to this conclusion. I was born and raised in Salt Lake City, Utah. The best part about that is the skiing, I will tell you. We, as a family, we lived in very difficult times. Economically, we were always on the bubble. I didn't know this so much then, but it was clear to me that we didn't have a lot of the things that many of my neighbors did. When my parents got divorced when I was 4 or 5, the economic bubble, the floor, everything fell out from under my family and me. It was my mom and my 2 older sisters, and we were left to figure out how we were supposed to make ends meet. My mom at the time probably made 20 cents to the dollar, so we started to work. And we didn't make ends meet very successfully. Our house was foreclosed on. I saw the car repossessed. I can't tell you how many times we had dinner without the lights on or the heat on because we just didn't have the ability to pay for it. So what I bring to this position is not only the intellectual capacity that we have and we need on our state's highest court, but that experience and understanding and empathy for what it's like for the struggles of many Oregonians.
The next question, we'll begin with Judge Surcombe. Judge Surcombe and the rest of the panel. Some justices in the Oregon Supreme Court have been identified with a particular judicial philosophy. For instance, Hans Linde is well known for his Oregon First robust constitutional analysis before turning to the federal Constitution. Do you believe that it's important for a judge to have a particular judicial philosophy before entering the bench? And if so, will you bring a particular philosophy, and what will that be?
I do have a current philosophy, if you will, Scott, for how it is I do my work as a judge. And I have, and it's more a matter of judicial temperament. That is, I pledged when I took my oath as a Court of Appeals judge that what I would bring to that job would be a curious and an open mind. I approach each case not relying upon my own intuition, but with a goal of analyzing the case and taking the analysis where it goes to find the correct result under the law for that case. I'm not one to prejudge cases. That temperament or that philosophy leads me to write often. As a majority opinion writer, I've written over 200 cases, opinions for the Oregon Court of Appeals, but I've also written a great number of dissents and concurrences because of the focus and the independent thought that I give to my work. That is my philosophy, to give each case its due.
Who's
I
next?
think we're going to keep going. Just go
Okay,
up around.
It's okay.
sure.
Having not served on the bench full-time, I don't think I would have a developed judicial philosophy that I could share with you. But as a pro tem judge, I can tell you what I've done in my 5 years, having heard hundreds of cases that have been presented before me. As a side note, of those 100 cases, as a pro tem judge, I've been appealed once, and that decision was AWOP'd by the Court of Appeals. The other thing I can tell you about my experience as a judge is in Multnomah County, either the moving party or the responding party can ask for a sitting judge or a real judge. You don't have to have a pro tem. And as to my knowledge, as far as I know, neither party in those 5 years has ever said, we don't want Judge Cook. She doesn't have the power to do it, the intellect. She doesn't have the ability to be fair. She's not balanced. So I take that as a great honor that at least the citizens of Multnomah County have entrusted me with their matters for the past 5 years. But I'd like to go beyond that judicial philosophy and let you know what I mean by, some people will call it judicial temperament. I guess I would call it humility. And for me, as a justice on the Supreme Court, that means at least 3 things. It means the intellectual firepower that one needs and would want on our state's highest court. It also means having the integrity that you need, unquestioned, in any regard, and I think I would bring that. And the last thing, the word I use is humility, judicial humility. And what I mean by that is there are 7 justices on the court. My 6 colleagues will have heard the same arguments, will have read the same briefs, maybe come to a different conclusion. I want to have the judicial humility to listen and understand where others are coming from. I may still stick with my opinion. I won't be afraid to write a dissent. But I also want to understand where others are coming from, because I really believe in this concept of diverse experiences, and I want the decisions coming out of our state's highest court to be the best they possibly can be.
This is one of the questions that comes up at coffees. I'm sure all of us have heard this question quite a bit. It was actually one of the ones that caused me to think the most, because people want to know kind of where you stand, and in judicial elections you can't tell them where you stand on particular issues. In thinking about the issue, it occurs to me that philosophy kind of has a connotation of ideology or position or almost dividedness or divisiveness. And I think Oregonians owe the Supreme Court justices present and past a real debt of gratitude, because they haven't become the kind of court that you see in many parts of the country that is divisive, where there's clear factions and everybody sort of expects Judge X to go a certain way and the other Judge Y to go another way. And to me, in Oregon, we're really blessed that we haven't gotten into the situation yet where it's politicized and highly partisan. So it's a deliberative body. They're looking to resolve things from the middle. You have to have a certain number of justices on your side to have a majority opinion. And I think it's very healthy that we've avoided divisiveness and sort of hard ideology. Need to speak up a little? Okay. So when I filed, within days, I put on my website my statement of core values, and that sort of helped me. The values that I followed as a trial judge for 11 years and that I would adhere to on the Supreme Court. They include deep respect for legal authority and the rule of law, integrity. Integrity means that you take the time, you discern, you take whatever times it's necessary to understand an issue, and I think what the public really is looking for is that after you've done that, you take a principled stand, and you stick with that principle even at great personal expense. So those are a couple of my core values.
For this question, we'll begin with Ms. Cook. Is there a United States Supreme Court justice, present or past, whom you admire, and why?
Yes, there are many, but let me just name a couple. Let's start with present, and you'll know why I'm going to mention her, Justice Elena Kagan. Here is this person who is extraordinarily brilliant, never spent one day on the bench, and you guys heard the criticism. How can she be qualified for the United States Supreme Court? She's never been a judge. But she was a dean of the Harvard Law School. She had so many credentials going for her, and the president said, this is the person I want to add to the diversity of the bench. Now, I am not saying I'm Elena Kagan, but what I am saying is I think, and we heard with the oral arguments coming out of the healthcare just this week, what she adds to the bench. She's got the personality, she's got the rigor, she's got the intellect, and I don't think now, even though she hasn't even been on the court for a year, I don't think anybody would say she doesn't belong there. So I would say Elena Kagan for starters. The other one I would mention is Sandra Day O'Connor. Now, side note, it's just coincidental that these two are women. I have to mention that right now on our Oregon Supreme Court, we have 7 justices, 2 of whom are women. So if I'm elected, that moves us a little closer to gender parity. But Sandra Day O'Connor, somebody who was well-respected, known by Republicans and Democrats. She wasn't aligned with one particular group. As the first woman, she really paved the way for those of us who have come since to make sure everybody knows that a woman can do this job. And she was asked questions that women and female judicial candidates have never been asked since. And so I admire her greatly for her service on the bench and the way she presented herself and her years and all her rulings.
Judge Baldwin.
Oh, okay, sorry. Justice Thurgood Marshall, I admire tremendously. Became a great Supreme Court justice, and he started off with very modest beginnings. His family was just one generation removed from slavery, and his parents instilled in him a love for education. Actually, the way he learned the Constitution as a child was because he got in trouble and they made him memorize it. But his parents really, his mother was a school teacher, his dad was a railroad porter. He studied very hard, given this ethic of education that he grew up with. And when he graduated from college, the University of Maryland wouldn't take him, even though his credentials were higher than anybody else that applied there, just because of his skin color. And so he went to Howard University, graduated first in his class, and went on to become a great civil rights lawyer. I think he still holds the record for arguing the most cases in the U.S. Supreme Court. Also went on to be Solicitor General, I think, and go on the U.S. Court of Appeals. And then President Johnson nominated him to be on the Supreme Court, where he served for 24 years. So tremendous inspiration for Americans who can see what you can do if you really work hard. You use the rule of law to help this country continue to grow and make progress and meet the promises that are in our U.S. and Oregon constitutions.
Before I answer, I just wanted to maybe break the news to Ms. Cook that actually the Court of Appeals issued a decision yesterday in the Untitled case that reversed a summary judgment ruling that you had made. I just wanted to know that.
Were you on that panel?
I was.
Oh!
But, you know,
I think that's a problem.
I did not recuse myself.
Oh!
You know, the justice, there are a number of justices on the Supreme Court that I admire for their contribution to the American legal tradition. But the one that has the most resonance for me in terms of what is going on now in current American law is Louis Brandeis. Brandeis served on the court, as you know, in the early part of the 20th century. He was a progressive. As a lawyer, he was the one that set the standard for pro bono public service, for what our understanding of what an ethical and involved lawyer does in his society. He was a pioneer in the law of privacy, dating from the famous 1891 Harvard Law Review article with Sam Warren on privacy. And throughout his career and his work on the court in that area, including very significant decisions defining the constitutional ambit of privacy rights and protections. He was also important in the evolution of court thinking in his protection of individuals against the excesses of corporation and the excesses of governmental entities. And it is that progressive tradition that started with Louis Brandeis that I think has the most resonance for me in the work that I do as a judge.
Okay. Okay, so we're moving from idealism and who we are as people to a legal issue. Some members of the Court of Appeals have been openly critical of the PGE approach to statutory construction. What should an Oregon Supreme Court justice look to in order to discern the intent of the legislature in construing a statute?
We're starting with Judge Baldwin, Circum, and Ms. Cook.
Well, I believe the PG&E case has been modified by State versus Gaines, which holds that The court can take a look at legislative history whenever it wants to, whether or not there's ambiguity in the text or the context. The starting point is to take a look at the text and the context, and if that doesn't answer the problem, then to go on and look at legislative history and intent. I think that involves also looking at the whole statutory framework around the particular statute in question and the particular problem in question, and then whatever I think the lawyers are responsible under State versus Gaines to bring forward the legislative history in detail so that the court may determine the extent to which that legislative history will help them determine the interpretation that is most consistent with the legislative enactment.
It's a really interesting area of law. I mean, how is it that you discern legislative intent? Judge Baldwin is quite correct that in the Gaines case, the court modified the PGE hierarchy, made it a little bit easier to get into legislative history analysis together with, in first tier, PGE analysis of text and context. You know, it is an issue that has been bandied about in the courts a fair amount. What is a legitimate source of legislative intent? A lot of us practitioners, appellate practitioners, would often cite testimony by proponent witnesses before legislative committees as to what the intent of the law is. But I think that is not, in fact, correct. The most primary intent, a source of legislative intent, is, of course, debates on the floors of the legislature, statements by the proponent of the measure on the floor of the House or the Senate, and sometimes the statement of the sponsor of the bill, presuming that it remains somewhat unchanged, before the initiating committee in either the House or the Senate. Really interesting question here arises in the context of initiative and referendum law. And how is it that you find legislative intent, that is the intent of the voters, in adopting an initiative or referendum measure? And for that type of legislative intent, you go to, you know, contemporaneous newspaper accounts and discussions, obviously the voters' pamphlet statement, the explanatory statement for the initiated or referred measure. So those are the sources from which you can discern legislative or popular intent in the construction of a statute.
This one is a tough one to go last because I agree with my colleagues. This issue was not settled for all time, but became more clear in 2009 with Justice Linder's decision in State v. Gaines. What she did in that opinion was quite remarkable, I thought. She took us back. She took us back to where this probably all began many, many years and decades ago. But she started with the construct in the Hoffman construction case, which was a 1992 Justice Gillette opinion. And in that opinion, he started out with the text of the statute to try to figure out if he could tell what that meant. If he couldn't go there, then he went into the context in which that particular phrase appeared. And that was the extent of his analysis. He didn't say do not look at extrinsic evidence, but there was no mention of it. But what was interesting to me about the Hoffman construction case is if it was ambiguous after looking at the text and the context, it was therefore construed against the drafter. Now that case happened to be a contract interpretation case as opposed to what Gaines was. Justice Linder's decision in 2009 was the statutory construction case. But she mentioned that in her analysis to get to the point where we've already heard the current state of the law is, which is you start again with the text, then the context, and then what you do and what Justice Linder said in Gaines was discern the legislative intent. Bring in extrinsic evidence to see if you can understand what it is the legislature intended with its language. And if you can't, then you you do the best you can with what the parties have brought to you. So what Justice Linder did is basically expand the definition, allow extrinsic evidence. So she even made a point in her decision to say maybe the decision wouldn't be any different if you analyzed it under this under the Hoffman construction. Maybe it would, but it gave us a little bit more guidance.
For the next question, we'll begin with Judge Surcom. Judge Surcom, in your personal or professional life, what recent or modern United States Supreme Court decision has caused you the most trouble, and why?
Actually, I do want to quibble a little bit with Ms. Cooks on her interpretation of state versus Gaines. I think that the shift in the court's thinking about statutory construction methodology is not from the Hoffman case, which deals with contract construction, but more from an amendment to ORS 174.020 by the legislature, which allowed for, expressly by statute, the introduction of legislative history in the construction of statutes. As to the question of what U.S. Supreme Court case particularly had resonance with me and my personal thing, you know, I am sorry that the current U.S. Supreme Court seems to have devolved to an institution that is highly political in nature. That devolution began for me with the Bush versus Gore case. It apparently continues in the current deliberations of the court on the Affordable Health Care Act. But what I do not like is for the court essentially making political judgments by people wearing black robes. It is one of the reasons, getting back to an earlier question that you had, Scott, about why I admire Hans Linde's work on the Oregon Supreme Court. Because Justice Linde's work was to try to transform tests that the judges did from a political calculation, an assessment, a subjective assessment of what the law should be, to one that's more objective in character. And Justice Linde did that with home rule formulation, with tort analysis and duty in the Fazzolari case. He did that with immunity issues in the Northwest Natural Gas case. He did that with a number of cases where he's substituted an objective test, a non-political test, if you will, for the political means the court was using previously to decide a legal question.
I would have to say the one that troubles me the most recently is the Citizens United case. We've heard a great deal about that, what that decision means. I think when it first came out, people didn't really give it much attention, didn't really know what it meant until the political season started. And now we know when the Supreme Court says corporations are people, or there's no limit on contributions. I think we have seen in this election cycle, and our guests now are starting to turn to the general, the unfair, undue, I don't know what word to use, that corporations and big money now has on our elections. I just worry as I've seen that case and seen it applied. I think we're going down a very dangerous road. I agree with Judge Surcom that I think it's yet another, probably the only time we'll agree tonight, especially since he overturned me. I think it does politicize the court. I think it makes the citizens of this country lose faith in the judiciary, which is a co-equal branch of government. And when the rule of law no longer applies, or people don't think it applies, or it doesn't apply to them, but it applies to me, I think that's a recipe for disaster. And I think Citizens United starts us on that path.
I tend to agree with my colleagues' opinions that they just indicated. I think I'll mention a different case so that we can consider effective counsel, effective representation under our Constitution. I don't recall the name of the case. I almost try to repress it sometimes, but it was the case where in a murder trial, a defendant had an attorney who fell asleep during the trial, and the court upheld that as effective counsel. U.S. Supreme Court upheld that as effective counsel. And to me, I don't know how an ordinary American can pick up the newspaper and see that and believe that there is a constitutional provision that relates to effective representation being provided when there's so much at stake. And of course, when you're talking about potential, I think it was a capital murder case, when you're talking about the potential death penalty and collectively us not offering that kind of representation in that type of a case, I found that very, and do find it very disturbing. Last week, I think it was, maybe the Supreme Court made up for it a little bit. Or a couple of weeks ago, there were 2 cases, companion cases, about plea bargaining and effective counsel. And in those cases, they were extreme cases where in one of them, I believe the attorney did not even pass on a plea offer that the state had given. And so the defendant was not even aware that he could have taken a plea offer. Very serious case where the plea offer would have given him 5 or 6 years in prison. And he went to trial because he didn't know about the offer and ended up with a 20-year prison sentence. So there's so much at stake in those kinds of cases that we really need to make sure that those rights are enforced.
This question will start again with Ms. Cook. Do you believe our system of electing judges makes the judges more likely to be cautious about authoring opinions that may be legally correct but politically controversial? And do you think this system for selecting judges is the best system?
Megan, I don't ever know what to say when I get that question on the campaign trail when people say, wow, Nina, how do you feel about the way we elect our judges? And I said, well, I'm in the middle of a campaign. It's the system we have. So it is currently the system we have, obviously. What I think is neat about this opportunity is, I haven't looked, maybe somebody in the audience knows, I believe this may be the first time in Oregon's history where we have 2 open seats, such that people can run for election. So this is an opportunity that we don't usually get as Oregonians. As a candidate, I think it makes it difficult, but it's also a really good experience. So I'm glad we have the opportunity to elect our judges, because that's the system we have currently today. What I understand is going on in the bar, and I support this effort, is I think it's the Oregon Law Commission, who's getting together a variety of people and interest groups to analyze if this is the right system for our state. You know, states around the country have different ways of doing it. Some don't have elections, some only have elections, some only have appointments. So what I think the commission is going to do is put all the options on the table and take a look at whether or not this is the way to go. Maybe what we should do as a state is only have appointments and then the judge run for retention. That's common in many, many states. So this is the system we currently have. This is the system the 3 of us are operating in. I know there's a movement to analyze different ways, and I support that. The last part of your question, does it make it more political? I'd like to think not. I'd like to think on our state's highest court and the justices, our justices that I know, I don't think they would be swayed by political pressure or opinion. Obviously, they're human beings, but they are dedicated to the rule of law, and that's how I would be if I'm elected.
You next?
I think.
Okay. First part of the question, does election of Supreme Court justices cause them to be maybe more cautious given that they're up for election? I don't see that having happened in Oregon yet. I can understand that as a consideration and sort of a pressure. Our Supreme Court, Oregon Supreme Court, fairly recently just had a case where on the death penalty case, there was a denial of right to counsel where the record didn't demonstrate that the defendant had really knowingly waived his right to counsel. The defendant was so troublesome and had such a history of being troublesome that the trial judge sort of preemptively forced him to choose between going forward or representing himself. And so that was a death sentence case where there have been many prior trials, and there would be this kind of political pressure on our Supreme Court, and it made me proud to be an Oregon judge, to see that our Supreme Court really had integrity and did what they had to do. You know, our Supreme Court is a democratic institution. The only problem that I have with somebody other than the electorate deciding those kinds of questions is I don't know if I'm going to get to be on the committee. And that's the real problem I have with it. If we don't do it, and there's a lot of difficulties with the undervote and the electorate knowing who the justices are and being able to make an informed decision. But I really worry about any other type of an insular group making that decision. Hell is paved with good intentions, and with the best intentions, I worry about such a democratic institution being subject to the decision-making process of some group.
I can't really give much illumination to the first part of the question about whether in the past, in fact, has a judge pulled his or her punches in anticipation of an election or in anticipation of an election challenger. I think I do know from practical experience in this election that certainly the time commitment in campaigning does take you away from writing very many opinions during this particular season. So it has that deterrence effect. You know, the issue of election versus an appointment system raises a number of issues for me. Like my colleagues, I think that there is some value in electing judges because of the legitimacy that it gives those judges, and that it breeds in the electorate a respect for the rule of law and the product of the courts that wouldn't be there if judges were appointed by a commission or the governor or a legislative body. On the other hand, there is no question that the election process, how you make yourself accountable to the voters, is very different as a judge than it is if you're running as a legislator or an executive, in which you can talk about the things that you want to do and try to gain some legitimacy from that conversation. Here, you can't really talk about those sorts of things. The whole platform has to be that you're independent. And the rise of big money in judicial elections is most alarming. The Chief Justice mentioned in remarks this morning, again, the Alabama Supreme Court race where there are $9 million, the Pennsylvania Supreme Court race where there are $6 million spent. All that is possibly around the corner for our state. And that has a fundamentally corrupting effect on the selection of judges and on the justice systems. And I think we need to look at our system of elected judges to see if it can be engineered in a way that avoids that pernicious effect.
To respect our audience, it's time to give you a heads up. We're going to have one final question from Janet Hoffman, and then we'll go to your closings.
Okay.
It's hard to be the last question when we've advanced to 10 afterwards. So this is just sort of like what got drawn out of the hat.
Who's up next on the
I think you are.
Oh,
Okay.
okay.
Judge Baldwin.
Glad I asked.
Okay. All right, here it goes. Oregon has a robust constitution. Our analysis is that we look at things first from an Oregon constitutional position and then address it with the federal. This has occasionally led to separate legal standards and guarantees under the Oregon and federal Constitution for apparently similar provisions. Is it important to maintain separate analysis and standards for similar state and federal constitutional provisions, or does it create too much confusion within the system?
I think you said apparently similar provisions in referring to state constitutional provisions and federal constitutional provisions. As I compare counterpart provisions relating to free expression, unreasonable searches and seizures, and right to remedy, some other provisions in the Oregon Bill of Rights, I see very different language. I see it's very interesting to review the language of some of the Oregon constitutional provisions and see that the absolute language and how much stronger the language is. For example, the Article 1, Section 8 is just absolute in restricting freedom of expression on any subject whatsoever. I think that sometimes leads to some opinions that the public has some difficulty with in Oregon, but that's what our Constitution says. That's what the Oregon Constitution says. And as I think about the fact that in Oregon, based on the development of Oregon constitutional law over the last 20 to 25 years, I think it's terrific that we have two different sets of tool belts, and that especially we've said some things about the U.S. Supreme Court here that were not real kind. So there's some examples now of where the Oregon Constitution provides more protection, more civil rights to Oregonians than provisions in the federal Constitution. And I think that's a very good thing. And I think it's appropriate that state Supreme Court justices make decisions about what remedies, what basic fundamental rights Oregonians are due, and add that to what the U.S. Supreme Court provides, and gives us a tremendous opportunity to protect Oregon citizens from having those rights detracted from.
I have a very strong feeling about this. There is no analytic comparison between the state constitution and the federal constitution. They both spring from completely different sources. The Bill of Rights that came about in 1787 was adopted based on the intent of the drafters of those provisions and approval process for those Bill of Rights based on the social norms that existed in the late 18th century. The Bill of Rights that emerged from state constitutional sources, from our Constitution in 1857, came from a completely different wellspring. Came from the intent of the drafters of that provision in our state constitutional provision, and comes from a richer and more protective civil liberties source than was the case for the federal government. There are very different textual provisions between the federal constitution and the state constitution, and analytically they are not congruent in scope, either by history, by text, or by the way they've been interpreted from the very beginning of the court's interpretation of those provisions.
I'll just follow up by what my colleague said, or to what my colleague said, with just a couple examples. We didn't get this prepared ahead of time, but the two that they mentioned, I'd like to just elaborate a little bit on. So one that Justice Baldwin mentioned is our remedies clause. So that's Article 1, Section 10 of our state constitution. I'm becoming more and more of a student of the remedies clause because so many cases fall within that, or courts use that to analyze so many different issues. So you start with the analytical framework of first you determine if in 1857, when the drafters of the Constitution wrote the Constitution, was there a common law right? And if there was, and if the legislature then abrogated that, was what the legislature substituted for that common law right sufficient? I think there's a different word, adequate, they use. So this all started in Smothers' 2001 case, and then the first time I became aware of it is in Linda's great case of Clark versus OHSU 2007, a decision by Chief Justice Muniz, and that was the case that the Supreme Court of our state analyzed the remedies clause to say that in fact the tort claim, the cap on damages for public institution, violates the remedies clause. That was an example of when the court used something very specific to our Oregon Constitution and applied it to a real life situation. Then in 2008, there's a case came out, Hughes versus Peace Health. It was a wrongful death case. So the first level of analysis that the court went to was, did the common law, was there a common law right when the Oregon Constitution was written and established? And the court said no. Wrongful death is a creature of statute. So the analysis stopped right there. So I'm just getting the time, but there's a similar example of cruel and unusual punishment under Article 1, Section 16. I agree with my colleagues that they're very different documents, and I think we have to start with the Oregon Constitution.
I hate to ask you to stand right back up
Oh,
again. Maybe I'll just give a brief remark so you can collect your thoughts. But we're going to have closing statements of 3 minutes each from the candidates, and the order will be the reverse of our opening statements. It will be Ms. Cook, then Judge Baldwin, and then Judge Surcombe, and then we'll have short closing remarks.
That's it? That's my
That's
break?
it. Sorry.
Okay. Thanks, Scott. Again, I want to thank you all for being here. This is a great honor to have an opportunity to share our thoughts with you. It's taken a great deal of preparation time for us. I suspect my colleagues as well. But I really know and value you guys being here, so thank you for that. Just a brief recap of what I hope you as voters and Oregonians, and many of you who are lawyers, will take with you in the proverbial voter's booth. As I mentioned earlier, you have to analyze each of the credentials and the strengths that the three of us bring. You also have to decide what it is that you think makes our court stronger. And as I've mentioned in my opening, and I hope have demonstrated for the past hour and a half, that diversity of experience that I would bring is something that we don't have. We don't have somebody right now on our court who has practiced in the public sector for 21 years, in the private sector, 21 years like I have, representing all kinds of people, all kinds of entities, all kinds of institutions, in a variety of what I consider very complicated issues. The other thing that I would bring, and I haven't had a chance to mention this is a statewide race. And those of us who live in Portland or the Tri-County area forget that we have this great, big, beautiful state out there. But when you travel to the outside of our Tri-County area, you are reminded, because people there tell you, you guys over there, or you are the other ones. There is a divide in our state, and I think those of us who live in the Tri-County area forget the importance of our entire state. What I bring, and I don't know the extent of my colleagues' experience, but I have traveled to every county in our state. I haven't just traveled, I've spent a great deal of time there with lawyers, with religious leaders, with business community. I have practiced law in almost all those states. So what I would bring to this position, even though I am from the Tri-County area, is a great appreciation for who we are as Oregonians and our strength and similarities, but also our strength in our differences. So that's the other thing that I would bring that I haven't had a chance to mention, but I would hope that you would consider. And then the last thing is, there's been some discussion in some newspaper articles about one of us is aligned with this group and the other is aligned with that group, and I'm right in the middle. Well, I can tell you the facts, and what the facts are, I am endorsed by both unions and the business community. I don't know if my colleagues have been endorsed by both. I'm the one that has the endorsements of both. I have gotten donations and assistance from plaintiffs' lawyers and defense lawyers, union people and non-union people. So I bring with me not only my diverse experience, my diverse perspective, and what I hope will be a well and balanced approach to the Supreme Court. Thanks again.
Okay. I think it's really important in this race that you view the experience that each one of us would potentially bring to the court through the lens of the Supreme Court as a deliberative body. There's no perfect profile of experience for a Supreme Court justice. When you look at candidates for a contested race, you don't just look at the candidate. You have to look at the other 6 justices and say, what do we need? What would help us the most to have balance and perspective? Balance and perspective, that's what gives us the very best decision making. And that's what inspires the most public confidence. And public confidence is really the coin of the realm for our legal profession in the courts. That's really fundamentally how we need to act in order to be able to get funding that we need for our courts and to protect Oregonians whose rights are violated. And so, you know, it's really, really important that we look at who's on the Supreme Court now. We have terrific people on the Supreme Court. As Nina mentioned, there's been a career path through the Attorney General's office. The majority of the justices are through the Attorney General's office and through the Court of Appeals. We need to balance that, and we need to have a balance based on trial judge experience as well. I have as much trial experience as Nina has, and I have twice as much judicial experience as Judge Surcom has. And I think that's why I should be elected to this position. I'm glad Nina brought up endorsements. I've been endorsed by Barbara Roberts. I can't think of anyone I'd rather be endorsed by. I think everybody understands the extent to which Barbara Roberts is concerned about the well-being of Oregonians. And so, with my very, very extensive trial experience, 25 years altogether, along with my practice experience, I'm the only candidate whose private practice experience, legal services experience, is only about individuals and their families. I think it's fine that we have other experience on the Supreme Court. Where's that experience? I can offer that experience, and that'll provide very, very important balance and perspective. And this is a time where we definitely need that particular perspective. And so I think that there's a lot of reasons why I'm the best candidate. I take exception to the suggestion that I'm not endorsed by both sides. I have all 3 Metro County sheriffs endorsing me. I have criminal defense lawyers endorsing me. I have civil attorneys on both sides endorsing me. So the support for my candidacy, and this is based largely on the fact that everybody understands that you need to have a former trial judge and somebody that can also bring extensive trial experience to our Supreme Court. It's a terrific Supreme Court. We can strengthen it.
Thank you again for the opportunity to present our qualifications to you. You know, each of us has argued here that our background and experience is just the ticket that the Supreme Court needs in order to do its work effectively. And I can't deny that Judge Baldwin has trial court experience that is useful when the court evaluates appeal issues that involve abuse of discretion by a trial court judge. That is not much of the workload of the Supreme Court. I also can't deny that Ms. Cook has particular expertise in employment law that would be useful in deciding those types of issues when they come before the Supreme Court. I have particular expertise from my practice history in land use law, administrative law, public law, together with a rich experience in civil litigation and appellate litigation. And I bring my expertise to the court really to fill in a gap of experience that exists there now. There is no one on the Oregon Supreme Court now, or as constituted in January, that has a background in land use and administrative law and public law that I do, and those are some of the more important types of cases that are decided by the court. But again, you know, from my view, it's not the substantive work that we've done that distinguishes us and that is important to look at as a candidate for the Oregon Supreme Court, but rather it is, as I mentioned at the beginning, whether or not each of us has the necessary background in legal analysis and writing and collaborative decision-making. That is the essence of what the Oregon Supreme Court justices do. I am the only person of the three of us who has experience as an appellate judge and as a successful and well-regarded appellate judge. That is, I believe, the best training in terms of legal analysis and writing and familiarity with the court's work that one can have to be on the Oregon Supreme Court. And that shows because 5, not 4, of the current members of the Oregon Supreme Court have been Court of Appeals judges before their service on that court. I'm the only one of us who has significant experience as an appellate practitioner before the Oregon Supreme Court and the Oregon Court of Appeals. Judge Baldwin has had none. Ms. Cook has had 2 cases before the Oregon Court of Appeals. As I've mentioned, I've had over 80 matters before both courts. That is an important proving ground for a person who aspires to be an appellate judge. It is there that you're trained on how to think and write like an appellate judge. I'm the only person of the three of us who's had experience either as a judge or a practitioner in all of the subject areas of the Supreme Court's work. And finally, I'm the only one of the three of us who is not tied by political support or practice history to a particular segment of the bar or interest group in the bar. And it's for those reasons that I seek your support of my candidacy for the Oregon Supreme Court. Thank you.
Thanks so much. I'd like to, a few concluding remarks, in particular thank yous. Thank you first to the audience that's participated. I want to give special notice that I noticed Justice Durham in the back of our audience. As most of you know, the seat that these candidates are running for is the position that Justice Durham is retiring from, and perhaps be appropriate in light of his long and distinguished history on the Supreme Court and the Court of Appeals to acknowledge and give him a round of applause for his great service. For the not so incredible work, but still important work, Bob Banks, for making available this conference room to us in the Wells Fargo Center, and to Bob's staff who helped, to the Oregon State Bar and their staff who made the video available and helped set everything up, and to the Oregon Lawyer Chapter of the American Constitution Society, to our moderators, Janet Hoffman and Megan Flynn, and finally, and in particular to our candidates, Judge Baldwin, Ms. Cook, and Judge Surcom. Thank you so much for participating. It's a May election, and if no one wins 50% of the vote, perhaps we'll be back here again with just 2 of you, but good luck to all of you. And please give a warm welcome or a warm thank you to our candidates.